Right. Good morning, Mr. Reynolds. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 10th, 2025, officers were patrolling the area of the 13,500 block of Beechnut Street, Harris County, Texas. And they observed a white Hyundai Kona with an aluminum pole stuck to its hood due to a recent crash. A traffic stop.
What?
A aluminum pole stuck to its hood.
An aluminum pole stuck to the hood? That's not something you see every day. Exploding head. This is the definition of probable cause. How fast do you have to be going for a street pole to become a hood ornament? Rate this moment from 1 to 10 on the most obvious way to get pulled over scale.
An aluminum pole stuck to the hood of a car.
Yes, Judge.
That's the basis for the stop.
Yes.
Okay.
This is word for word what when I observed a white Hyundai Kona with aluminum pole stuck to its hood, comma, recent crash. I then got behind the vehicle and yeah, finished it. Yep.
Yeah, keep going, please.
Okay. I went back and got behind the vehicle. The officer started speaking with the defendant, who admitted to being driving and that he had crashed. The defendant told me that someone swerved into his lane and crashed into the pole. The defendant stated that he already called his record and that he was good to go. The defendant did not show any intentions of going back to the original scene and gave his information. While the officer was talking with the defendant, a security officer told the client that some people flagged him down the street, saying that the defendant crashed into multiple parked vehicles and drove off. The officer detained the defendant and went back to the original scene, which was a quarter mile from where the officer found the defendant.
Now that adds to it. I mean, that's certainly.
The officer spoke with a witness who stated that he was by the front of the apartment when he saw the white vehicle losing control, crash into a pole, and kept on driving while hitting another two vehicles. The witness stated that he was going around 60 to 70 miles per hour in a 35 mile per hour speed limit zone. This confirmed how the aluminum light pole got stuck to his hood. The witness stated that he did not see anybody else around the vehicle before the incident. The officer spoke with one of the owners of the vehicles that was struck, and she stated that it will be around $200 to fix her vehicle and wants to pursue charges. The complainant of the other pickup vehicle had damages to the back right part of that vehicle, and the complainant stated that the defendant crashed into her vehicle and left without providing information. The defendant left the scene without, okay. At this point, they called intake, and then they completed an inventory search of the defendant's vehicle and located a black backpack with 7.4 grams of marijuana, multiple clear plastic bags, and scale.
Is he under arrest? I mean, if he's
Yeah,
under
so
arrest,
they
then,
called,
but I didn't hear that he's under arrest or anything. They just up and go start searching?
Here's where things get legally tangled. The officer starts searching the car, but was the defendant even under arrest? If not, that's a possible Fourth Amendment issue. What do you think, valid inventory search or constitutional overreach?
they did say that the officer called DA intake and spoke with an EDA who accepted charges of the FSGI. And then it states there was an inventory search conducted.
Okay, so they did arrest him but what happened? Because is there an FSGI charge?
We're going to be honest, Your Honor, I'm not entirely sure what happened there. I'm working on it right now. If there's FSGI, right now I'm working on the complainants. We can get things worked out that way.
I mean, I don't
Right now, we do
understand.
not have an FSGI charge at this very second.
Did they accept it or did they not accept?
Based on the DIM statement, it says that we accept the charges. So I am trying to see why there is not a charge, but it's not something that I know.
What a weird day so far.
Your Honor, Can I say something? Your Honor?
No, don't. Now's not the time. I'm gonna give you a lawyer and you can tell your side to the lawyer, but,
I think it was a glitch in our internet system, so they could find marijuana, but they just, wherever, yeah, that's check.
is it going to go through? Do you know?
I need to look into our system, our insurance, to figure out why it didn't, talk into it. If worse comes to worse, we can make it a grand jury. But
So I'll give you, I guess, let's do this. I'm gonna appoint a lawyer today and I'm gonna find probable cause for the moment, but I want to revisit it within the next couple of days to see what is going on. And then, all right, so I am gonna find probable cause for now, Mr. Reynolds. Can you look to see if he has a license, please?
Yes,
Driver's
Judge.
license. How old are you, Mr. Reynolds?
I'm 26, sir.
His driver's license is not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life. I don't care if you need groceries. I don't care if you need this, that. If you don't have a license and liability insurance, you're not allowed to drive. No, I will give you a lawyer today. You can say your side to the lawyer, but if you don't have a license and car insurance, you're not allowed to drive. Do you understand?
Yes, sir.
That is a condition of your bond. If I find that you do, I will revoke your bond, put you in jail, no more PR bonds for you. So what I can have you do is I'm going to have Deputy Miranda give you an application. I'm going to have you fill it out. I'll have you talk to a lawyer today. But unless I guess let's do that. I'll have you talk to the lawyer and then we can revisit the situation after you talk to the lawyer. Please.
Thank you, sir.
Hi, Judge.
Hi, bud.
Approaching on Reynolds, I think, reapproaching on PC, I believe. He's over here on a possession of marijuana. She said you wanted to reapproach, so that's
Well,
what it seems awfully fishy. I'm not sure why they detained him for FSGI. I do not understand that.
I think that there's a valid claim for an FSGI because someone says that there's a guy barreling through a neighborhood, hits a bunch of cars, takes off. We have someone that puts him there, right? That
Yes.
says it's him. My concern is that they say they accept charges for FSGI, right? But we only have a POM.
I understand.
I don't get it.
I
Just-
understand. That makes no sense to me either.
So what I did was I found probable cause for now. I'm going to give them another couple days to figure out what happened. Why was it a glitch in the system? What,
Just for what it's worth, according to my client, he was on scene. He wasn't away from the scene. He was by his car when they were arrested.
See us?
way away from the accident.
Well, the accident happened and the car went forward and hit something. Anyway, it's okay. But
Show me.
either he's FSGI and they can prove that he belonged to that marijuana, or they can't prove that he
So
belonged to that
let's do
marijuana.
this.
That's fair.
Why don't we set it for a formal probable cause?
That's fair.
Days, you pick it, I don't care.
Next week, okay?
Sure.
Okay, sure.
And then that gives them enough time to also look into
Gotcha.
what happened with the FSG, why is it not, you know?
Sounds fair.
In the interim though, come up.
Mr. Reynolds?
You tell me he doesn't have a license, right?
It is not eligible, Your Honor.
Like, I have here that he's trying Uber or something like this.
That's correct. That's my
You can't
understanding.
drive. You don't have a Texas driver license, right?
Come over here. Come over here.
No. It's a yes.
Do you have a valid Texas driver's license?
Yes, as far as I was aware.
They're looking into the Texas.
I understand what that just
system.
said,
It's
sir.
not valid.
Right.
So you don't have a license.
I understand that now, sir.
You can't drive.
I understand that,
Don't
sir.
drive.
Yes, sir.
If I find that you drive, I'm gonna lose it.
I
I'm telling you
understand that,
now,
sir.
I will put you in. Because all I'm asking you to do is follow the law. I'm not asking much. If I find that you're driving, and I don't care what your excuse is, I don't care if it's a burning building and you have to say 50 kittens, I'm gonna lose it. You will be signing a promise with me. This is an affidavit that you're gonna promise me that you're not gonna drive. Do you understand? It can go really sideways if you do. All you need to do is contact DPS to figure out what you need to do to get your license back. I'll even give you the phone number. Let me stick these-
I already have that information, sir.
Oh, there it is. I always.
Yellow, you want blue? He's gonna give it to you. Just let him give it to you. Call me this afternoon and we'll figure out why it's not valid.
So this is the number to the driver's license division, to DPS. When you call them, call at 7 in the morning. Don't call at 9, at 2, at 1:53. You'll never get through. You have to call when the phone lines open up, give them the number and ask them why it's no good, and they'll tell you.
I need an SL22.
Oh, well, there you go.
I had
Then you know why.
Oh,
almost, I was just working Uber every day, so I didn't know.
So you can't do that. Don't worry. You don't need to say anything else. He's got it figured out.
look, Mr. Reynolds, do not drive. Do you understand?
Sort it
Yes,
out.
sir.
And you need car insurance before you drive too.
Oh,
Just, we'll fit.
Okay.
We're gonna be back next week, so we can answer all your questions next week. Or between next week, I'll answer them. All right.
gotcha.
Hopefully you can get that sorted out. Come back, that thing says eligible, you'll be good to go. All right? Then he'll lift that restriction, I think is what he's saying.
Okay, come on up, Mr. Reynolds. We'll have you sign this and then you'll be free to go. Good morning, Mr. Ibarra.
Good morning, sir.
So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you would like. Okay. On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being in the 114th Street Bounty Hunters gang and is 18 years old.
Okay, so was it really that, did he shoot himself or do we know that someone else shot?
We do not know. We
So-
know that the casings on scene match the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well. So it's unclear.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending.
Sir.
When you hang with dogs or when you're bad places in the middle of the night, really, do something with your life. Get into school, graduate, get some knowledge.
Sir.
Take a seat with me.
I have Ms. Salmaron on the docket, Celia Salmaron.
How's she doing?
She did a T-RAS. It looks like they're recommending like the women's residential. Yeah.
Yeah, that's a good idea.
So the issue, Judge, she needs to be on a probation. She has 2 open PCSs currently.
No rush. Really.
She's
That's probably the appropriate thing.
okay. So her felony court date is March 28th. And the problem is that I just, so she has the old PCS, but she has a new one. And, you know, she's not going to be able to bond out. The felony court did give her bonds, but she's not going to be able to afford those. And
What are you asking for?
a trial date. My problem is, Judge, it could take months and months for them to get the lab back on the PCS. Or I can get a
Do they have
reason.
the last bag? I mean, how long?
I'm sorry, I didn't catch.
So-
Salmaron.
Okay, okay.
Yeah, it's an old case, Mom. You're right. I didn't realize it's from May of last year.
It does appear that the labs are still pending.
Yeah, is it really going to take that long to get? I mean, how long do you think it'll take? Do we have any, are the labs back on the first case?
Yes, Judge, I think they are, because I think they're in connection with this DWI.
Have you evaled? Are you ready?
I'm ready. I mean, I was ready before she forfeited, so.
The labs are back on the second case.
It's the same case as our case. Yeah, I have no idea how long it takes to get labs back. You don't know? Still
No idea.
on?
We have an offer in there. It's an old case. We can set it for trial today if that's what you want to do, Judge,
It's not
but
me, it's Connor. I'll do whatever you want. It doesn't matter to me. If you want to set it, I'm fine. If you want a little bit more time, I'm fine with that too.
Yeah,
You tell me. You're in the driver's seat.
I think that, so she has court next Friday. If we could get just a couple week reset, see what happens next Friday, see if they get the labs, and then if not, then we can.
And, perhaps have her see how long it'll take.
Yeah, and
Ask someone else.
I'm gonna reach out to her felony attorney and then maybe the prosecutor, see if we can't work out something.
Global?
Yeah.
That or ask them, hey, how long does it take? If it takes 6 months to get a lab back, I mean, that's unreasonable.
Yeah.
I'm with you at that point. So,
for the time being, I'll put an email to do it for us.
For sure.
Next setting meeting.
yeah,
Sounds good. Thank you, Judge.
for sure. Morning, Mr. Eli. Come on up. How are you? I know you don't want to go into treatment, right? And I acquiesced to you last time. You asked me, please, I can get it done. Please don't let me do it. Don't put me in residential. Don't. And I listened. And what happened? No. Yeah, you caught a felony DWI, not. We put you on probation. A month and a half later, you pick up a felony DWI. So all this, acting. So now, if this doesn't show that residential is the right thing, then I don't know what does. The only thing that we're trying to do is prevent death on our roads. That's the only thing, right? And somehow we have to get through these. Every other way that we've tried just doesn't work. This is the only other thing that we have left at our disposal. So if you want, we can just set it for a hearing. And if they prove to us that you have violated your probation, then we're going to amend your conditions to put you in residential treatment. We can do this any number of ways. We can have a full-blown hearing, or you can just sign the conditions. But if they prove it to me, that's what's going to happen.
I'm not signing the conditions.
Okay, so set it for a hearing, and then get the probation officer here, and then we'll see. And then they prove to me that you have violated your probation, then I'm going to amend your conditions. I'm not letting you go. Ever. Do you understand? I'm going to keep you until we get this straightened out, one way or the other. Okay? Understand? Okay, good. So I'm at your mercy when you want to set it. You want to do a week, we can set it in a week and then just have a hearing. It's just at the mercy of the probation officer, whatever they are best with. Okay? Good morning, Mr. McCann.
Morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said that defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you said?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time and the defendant was aware. So this baby refiled as a felony. I'm not sure yet, but throw that right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons, and I'm
Judge Fleischer's tone shifts here, and you can feel the weight. He calls a violation of a protective order the capital murder of misdemeanors. That's not courtroom drama, that's deadly serious. Should more judges take this kind of hardline stance?
now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those violate conditions, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it was the first one.
Okay. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parham. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with Felicia for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
Oh, there
it's
is.
bond said, Judge, with regards to the bond condition, I was wondering if we could, amend those or have them reflect the no threat and harassing communication, instead of no contact. They do.
They haven't been able to reach her.
They haven't, but the DA hasn't, but then she has spoke with her back. And she had spoken to the back and told her that she didn't want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant, you
no, she's
know,
already had the child. They already have a child now. That's the only reason why I say now,
Yeah,
because
this did happen back in June.
they do have
Yeah.
a
If,
child.
well, let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, you know, and if you could, you know, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm gonna order it. If she does, then we can revisit it at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I gotta go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right.
Thank you.
Thanks, guys.
Judge.
This way.
Good morning, Mr. DePaz.
Good morning.
So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Oh, thank you.
On March 10th, 2025, at approximately 12:18 p.m., a school resource officer responded to a security officer needing assistance in LaPorte High School. Upon arrival, the defendant was placed in the security resources office after a physical altercation. The defendant stated he was upset with the complainant because the complainant had mistreated his sister in the past. The defendant confronted the complainant and struck the complainant with a closed fist on his face. The defendant was observed on school CCTV walking up to the complainant and punching him with a closed fist, and shortly after, the complainant fell to the ground. The complainant did not show signs of confrontation towards the defendant. The complainant was observed with multiple lacerations on his lower lip and a missing tooth from being struck in the face. The complainant was also observed with a swollen jaw and bleeding from his mouth, and the complainant felt pain. I have spoken to the family of the complainant. He's had to have his jaw wired shut. His jaw was broken on both sides of his face.
Serious bodily injury?
I don't believe that would rise to the level of serious bodily injury because it's not permanent disfigurement, because he will heal eventually, but it will take 6 to 9 weeks for
Mr. DePaz, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're smoking weed, if I find that you're using alcohol, I will put you in jail. You will get your degree with me. Do you understand? You are now not to go back to LaPorte High School. I'm ordering you not to go back. I don't want this person to live in fear, so you're not to go back there. Do you understand?
Yes, sir.
If I find that you become a danger to my community, I only have one place for you.
Yes, sir.
You're not to be in possession of weapons as well. You were what, 17?
Yes, sir.
Okay, I will provide you a lawyer today. I'm sending you for a drug test. I want to know what, if anything, is going to be in your system. You're to take a test and you're to come back, and then I'll have you speak to a lawyer.
Yes, sir.
If you don't go take the test, if you don't come back, I will issue a warrant for your arrest.
Yes, sir.
I it's your problem. You got out of jail because we gave you a free bond. You're not going to get another one if you're a danger to my community.
Yes,
You
sir.
understand?
I will not cause any.
Okay,
And Judge, did you say no contact with the complaining witness?
Correct.
Okay.
but don't worry, don't file anything because I'm going to have him supervised.
Okay.
All right, so just reach out to the night for him, please, and then I'm going to send him for a test right now.
Okay. Well,
Rand, how are you?
Right, how are you?
Judge looks very festive today.
So this is an FSGI, am I right?
Yes, sir.
Hola, yo te voy a interpretar, ¿ok?
Good morning, Ms. Reyes.
Sean Díaz, señora Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information.
Escena de un accidente sin intercambiar la información que necesitabas hacer.
You are facing up to 180 days in jail
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Soldados,
You have the right to remain silent. Anything you say can or will be used against you.
está contra usted.
I insist she stays silent.
Y tu abogado insiste que se quede callada.
Just please go slow.
Yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
officers were
los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle Safer
Seth Street in reference to an
Street.
FSGI.
bajo una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger
oficiales
left the scene
dijeron que
following
un
an
White Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y iba
Street.
en camino al sur en la calle Shaver.
The complainant stated that she
quejante
was
dijo
traveling when a
que ella
white
estaba
Dodger
manejando
made a
cuando un
unsafe lane
Dodger
change
Cambió de carril, pero sin,
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó
Which-
al oficial
showed the license
y
plate
tenía la
and
placa.
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Vieron la
owner to
placa
be
y
Juan Maneno.
encontraron que el dueño era Juan Veneno.
The officer located the vehicle at the apartment complex
Encontraron
where the
el
vehicle was
vehículo en
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who is
habló
the
con Juan y
defendant.
la esposa, que es el acusado.
Juan advised the officers that the
Y Juan
defendant
le
had been
dijo
driving the
que el
vehicle all
acusado
day,
estaba
and that
manejando
the-
todo el día el
and
vehículo.
that the only damage to
que
the vehicle should have been on the
daño
front bumper from a
que
previous
tenía el
incident
vehículo
and
era en
nothing
la
else.
parte de frente de un accidente previo.
The defendant advised
el
officers
acusado
that she was
le
driving the
dijo,
vehicle and had
ella estaba
recently gotten
manejando
back from a Walmart,
El vehículo y había regresado
which is
de
around
Walmart,
700
como-
feet from
como
where the incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente.
anybody.
Y ella negó pegarle a cualquier persona. Negó que
Your Honor, so based on the
y basado
information,
en la
the
información dice
car was registered to his wife.
So, how do we know who's driving
And
it?
the complaint,
¿Y
the
cómo sabe quién
Juan
está
stated that
manejando?
he was the one driving and she admitted to being in that location at the time.
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she
Sí.
was the one, within 700 feet of the accident and that she had
Estaba
access to the vehicle, Your Honor.
Tenía acceso al vehículo y estaba a 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
Did you say that the husband said that she was driving it?
She was driving
El
it all day.
esposo dijo que estaba manejando.
Statement.
Dice que sí.
Do you want to add anything? Did you want to say anything?
No, well,
Yeah,
two
yeah,
things,
yeah.
Judge. Number one, there was no evidence that
No hay
she was,
evidencia.
as you mentioned, there was no evidence that she was
Que ella
driving the
estaba
vehicle. And just because she had the vehicle all day does
Solo
not mean she
dice
was
porque
driving
tenía el
it.
vehículo ese día.
For example,
No
when I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque, por
and she's using one of our vehicles, I'm sure that
Mi hija
her lunkhead
está usando,
boyfriend is probably driving it the majority of the
vehículo
time.
puede ser que
Additionally,
no,
this
el novio de
vehicle
mi
is
hija estaba
insured.
manejando. Ahora, el vehículo
There's never been
tiene
any
su- está
report
asegurado.
of anyone, but
Ningún
people had
reporte.
consent to driving it. That defense is not going to be erased, so this is an
Yes, sir.
insured incident.
It's just,
Es un incidente
you got A, you got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba.
don't think there's enough.
Okay. Sure.
All right, I'm gonna find no probable cause in your case,
Van a
man.
encontrar que hay motivos fundados para mantener, pero
Please be careful when you're driving.
ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejar
and liability insurance in your name.
y seguro.
Do you understand?
¿Entendido?
Okay, all right.
And she does, for the court's edification.
Thanks, Jamie.
Always great seeing you, and I apologize on the record for calling in my future son-in-law as a lunkhead, in case that goes anywhere. I forgot it's being videoed. All right, take care.
The cause?
I keep forgetting.
Are you Ms. Jacobs?
Yes, sir.
Ma'am, you're charged with failure to comply, I guess striking an unattended vehicle. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On February 27, 2025, an officer responded to an FSGI call in the HEB parking lot in Houston, Harris County, Texas. The complainant reported that while shopping, her vehicle was backed into by an unknown individual who did not stop. When she returned to her vehicle, a note was left with a license plate number, a witness's phone number, and a statement about the incident. The witness confirmed seeing a vehicle back into the complainant's vehicle and drive off. The witness gave a description of the defendant and her vehicle. On March 4th, 2025, an officer met with the loss prevention manager at HEB and was shown surveillance video from the parking lot, which showed the defendant driving over a curb and parking her vehicle. The defendant did shopping in the store and got back in her vehicle. The defendant began to reverse into the complainant's vehicle. The defendant paused briefly before driving off and exiting the parking lot. Surveillance video clearly showed the defendant as well as the defendant's vehicle's license plate. The officer confirmed the license plate was registered to the vehicle and the registered owner was the defendant. The officer compared the driver's license photo with the surveillance images and positively identified the defendant. The officer called the defendant and the defendant acknowledged he rubbed another car with her bumper. The complainant provided photographs of the damage to her car along with an estimate that the total cost of repair would be $3,009.23.
Okay. Ms. Jacobs, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run her license, please? See if she has a valid license.
Yes, Judge.
I'm ordering you not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. That's the only condition I'm putting on you at this time. Do not pick up any new cases. If you do, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am?
Driver's license is eligible.
Okay, so we're just going to craft bond conditions for you not to drive without insurance as well. We'll have you sign it, and after that, you'll be free to go. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you if and when you have to come back to court. If he tells me he can't get hold of you because you've gone AWOL, I will issue a warrant.